Advocate Lucinda, your empowerment lawyer, and I want to empower you today. Some of you have contacted me and expressed your frustration about the charge, your race discrimination charge that you filed with EEOC. EEOC informed you that your charge was untimely filed and that you would not be able to file a lawsuit. However, there is another statute, a statute that a lot of people don't know about, that has a longer statute of limitations than what EEOC or Title VII of the 1964 Civil Rights Act provide. You want to hear about this statute, so let's get started. So let's look at the classes of people who are protected under both Title VII of the 1964 Civil Rights Act and 42 U.S.C. 1981. Under Title VII, of course, we've gone over these: race, color, religion, sex, national origin. Individuals who fall under any one of these categories would be protected from employer discrimination. Also, the EEOC enforces the American with Disability Act, known as ADA, and the Age Discrimination in Employment Act, known as ADEA. 42 U.S.C. 1981 exclusively protect individuals who fall under the category of race. And another interesting thing about 42 U.S.C. 1981 is that the racial component is not limited to the employment context. So it's a pretty solid statute protecting individuals from race discrimination. One of the requirements that must be present before an employee files their EEOC charge, they must be certain that the company they're suing has at least 15 employees. However, under 42 U.S.C. 1981, there is no number that has to be met. That's a benefit that Title VII does not provide. Under Title VII, the company can be sued and the company will be named in the complaint. Again, because you cannot sue a supervisor or one in a supervisory position under Title VII. They cannot be named in the complaint. However, under 42 U.S.C. 1981, individual supervisors or those in a supervisory or authoritative position can be sued and they can be named in the complaint. And another thing I want to say about Title VII supervisory liability, there's a term we use called respondeat superior or vicarious liability, depending on the jurisdiction you're in, suing in. It means that the employer or the company would be liable for the acts or actions of an individual in a supervisory position who the employee identifies as having been one of the bad actors, if you will. A plaintiff filing an EEOC charge must wait for EEOC to complete its investigation and EEOC will issue a right to sue letter before they can file a lawsuit in federal court. However, under 42 U.S.C. 1981, the plaintiff does not need to exhaust any administrative procedure and can sue immediately if they wish. The statute of limitations. This is a big one for people because a lot of people have EEOC to tell them, well, you filed your charge too late. Well, you are going to be happy to know that under 42 U.S.C. 1981, the employee has a longer period of time to wait before they file their lawsuit. Under Title VII, the employee or claimant will file the charge within 180 days from the last date the discrimination took place, or 300 days depending on the state. And once the employee or claimant has received the right to sue letter, they have 90 days to file the lawsuit in federal court. However, under 42 U.S.C. 1981, the plaintiff has 4 years to file the lawsuit, as long as they file that lawsuit within the 4-year period. That's a lot of time when you compare it to Title VII. Very powerful. So let's talk about damages. Under Title VII, there are limits on compensatory damages and limits on punitive damages. And that's going to depend on how many employees the company that is being sued employs. However, under 42 U.S.C. 1981, there is no cap on damages. The individual who is suing can sue under both of these statutes at the same time. I am confident this has been helpful to you. And until next time, be